Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running a theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear a shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Hey guys, it's Squid. Welcome back to my channel. Thanks for your patience with me. I have a brand new desk. Thank you. I could not have done it without chat. Specifically a certain someone in chat. You know who you are. I'm not going to shout you out because I don't know if you want that attention. But without a couple people in this chat, I would have absolutely nothing. So I am grateful to every single one of you. And my dad is in chat, and yes, I am very grateful for my father too, because he has helped me out quite a bit. But this specific purchase and this thing was not my dad. So saying hi to everybody. Thanks, Unhung Hero, for getting us started with 10 gifted Squid Purple memberships. Always turn in the chat green. And I owe you members content. I really do. Hey, Jeffrey, as always. Kate Davis, hope you had a great weekend. I'm glad you're here. Jeff Grady, good afternoon, sir. How are you? Tammy, Dad, as always. And I need to apologize publicly to my father because I was a little overwhelmed this morning with trying to get this up. And he asked me about going live. And I was so overwhelmed and I was dropping shit when trying to put this mic stand together. And I was just like, I gotta go. And I was like, so I need to publicly apologize to my dad. It was not meant to be snippy at you. I was just stressed. Because having a screaming toddler in the background when you are trying to do anything productive is a requirement. Anyway, Gail, good to see you. Roy, Jake Hetty Buck, living life good. How are you? Zohan, so good to see you. I've missed you. Kathy, how are you? Nice digs. Yeah, I know, right? I mean, this has always been there. The panels on this wall and this picture have always been there. This bookshelf's always been there. It's just this, my filing cabinet was over here with the printer on it. Always up against the wall. Because I was like, my desk ended like right here. Now I have all this room and this extra part right here, and it swivels. So if I want to change it to a straight desk and have it go all the way to the window, I can. If I want to change it around, all I got to do is mess with the drawers and change the faces on the drawers, and I can basically switch it around and have it over. It's fucking amazing. Anyway, I'm a little too excited over a desk. But it's like, I got space. I got space to put stuff. Like, and this desk is better than my old one because I'm now able to use my mic arm again. It's like, just which took stuff out of the closet because stuff that I wasn't able to be used. I have both sets of lighting up because they both fit. Y'all can actually see my little lamp here that I've had for like weeks, and it's just been out of the way, so y'all couldn't see it. It's just great. A big desk, harder to knock stuff off of it. Yes. Yes, and it has no shelf. So it's all one level, which I liked the shelf, but I was looking up and I had to sit on a pillow or an extra, thing just to like but now it's like it's all good. I'm happy. Okay. So speaking of, before we get started on the topic, because this is long overdue, these documents are actually from the end of August. However, everything's been so busy that I never actually like dived in. Like, I saw there was new documents but never looked. So there's this, but the first thing that we have to get to is an article that I was sent last night by the person who originally sent me this case. I have been covering this case of Christopher Schultz since it happened. I've covered every hearing that has been televised. I've covered every document that I've been able to get a hold of, and it's Arizona, so there's not a whole lot. However, I've been covering everything that I could get my hands on for this. We covered the plea deal. So, TLDR, Christopher Schultz is 38. In the summer of 2024, he left his 2-year-old daughter, and at the time, baby Squid was 2. So, like, it hit close to home. He left his 2-year-old daughter in the vehicle, and she unfortunately did not live. So I was really like, I mentioned it to someone this morning when they were talking about it on their stream, and they were like, I couldn't cover this because I couldn't have been non-biased. And I'm like, I've never claimed to be civil in this case. I've always basically said that this guy sucks. However, he was supposed to show up to turn himself in due to his plea deal. Well, he never showed up. So this is what I was sent last night. Pima County Attorney's Office confirms Christopher Schultz took his own life. Usually I am not the kind of person who would celebrate someone self-deleting. However, you left your kid in a car on in Arizona in July. Like, you just And hey, Kat and Karen, how are you? Tammy, thanks for being a member for 10 months. Hi, I can't stay long. Mom's in the hospital. Oh no. Let me know if you need me. Yep. Yes. So Pima County Sheriff's or County Attorney's Office has confirmed that Christopher Schultz, the Marana father who pleaded guilty for the unaliving of his 2-year-old daughter after leaving her to perish in a hot car, took his own life. On November 5th, Pima County Attorney Laura Conover released a statement regarding the death of Schultz. He was scheduled to appear in court on Wednesday for a hearing in Pima County so he could be taken into custody as part of his plea agreement. Instead of coming in to take account for what occurred here, we have been informed and we have confirmed that the father took his own life last night. Deputy County Attorneys Haley Wiegold and Brad Terrace, alongside victim advocate and chief of detectives, have informed Schultz's next of kin. I mean, there's more details that have come out about it. However, that's all I'm going to say about it because Good riddance. But now she's got more room to get back here too. So good luck. She's okay. I'll tell you about it later. Hopefully. So if you see things changing with this lamp, she likes to play with it. So it's her new favorite thing. So wish me luck on that one. However, he knew he was going to get, yep. Yeah, but now he doesn't get 3 meals a day and the taxpayers don't have to fund his life. So I could never. It's one of my greatest fears in life, which is one of the reasons that I was covering this case, was because it has been living in Southeast Georgia and having it get extremely hot. Like, it's November. Most people are, bundled up in 40, 50 degree weather, tops during the day. It's starting to snow places. It's 75 here. It gets cold at night, but it's 75 right now. Like, so it's 75 in November. July, it's pretty damn hot. My greatest fear in life is this little one in the back seat. So, oh yeah, well, here's the good thing. The drawers are right here, so she cannot get into my drawers while I am working, which is oh so nice. Oh so nice. So we are going to get into the whole reason that we are here. The Zachary Young had won a defamation case against CNN in January, which we still haven't watched the entire case on this channel. We started to, and then life gets in the way. See, she loves, this is her thing now. Oh, I love you, but can you take that and go somewhere else? Mm-mm. I was looking through old cases this morning, and I knew that he had sued the Associated Press and U.S. News and World Reports for the article that they wrote talking about him winning a defamation case against CNN. And it was given to the same exact judge in Bay County, Florida, which I'm not really sure. And I know Jeff will probably let me know this. I'm not exactly sure where Bay County, Florida is. I'm assuming it's Gulf side, but I don't know for sure. So, oh, we got good news yesterday. Surgeon relief wife with no restrictions. TT tomorrow to see if she can work. Yeah. Yay! Get that CT done and get back to it. Hello. Panhandle. Okay. Thank you. I was like, I was thinking it was somewhere on the Gulf side, but like north of Tampa Bay was where I was thinking. So, all I know is he had the same judge as he did in the first case, which I thought was interesting. And that's where this video came from. Maybe not. I thought I had that video. The video of the judge actually saying what defamation is and talking to the jury. Zach Young is a Navy veteran who owns a special, I don't exactly know what his company does, but he works overseas and he extracts people from places. I don't exactly know what you would call that. Hello. Glad to be alive today. It's a day. Well, CNN had written an article, CNN had done a segment on Jake Tapper's show. I'm having to go in the Wayback Machine in my brain, which, if y'all know me, it takes a little bit of effort. Jake Tapper had done a segment on his show talking about the botched withdrawal from Afghanistan. And I'm not going to talk about all of that because my blood pressure will jump. However, they mentioned his they talked about him or showed his picture or something, and basically that's defamation. That was defamation. They basically accused him of blackmailing people or extorting people to get civilians out of Afghanistan during the withdrawal. Um, but while he did win against CNN in a jury trial in January, Angel, I love you, but girl, you're distracting the hell out of me. So you either got to go that way, Angel. You got to go somewhere because you're distracting the crap out of me. You're not fine. Take the water. Here, come here. Come here. You can come over here. But you are distracting the ever loving crap out of me. I'm sorry, I love you, but you distracted to high heaven. Can we get a live action baby squid GoPro? Oh my goodness. Oh, yeah, this Angel, I love you, but you're distracted. No. No. Uh, sort of. I don't exactly know. Girl, mm-mm. Hold on. I have to do some mama stuff. Sorry, she's got this really bad habit of drinking water, not swallowing it, and spitting it all out, and I could see it, and then I could hear it. She was spitting water all over my floor, and I was like, "Nope." I let her get away with a lot of things, but I have my limits, and that's one of them. So, it's set her up a little fake studio and tell her that she's your co-host. Baby Squid was trying to look innocent so mom wouldn't pay attention. Yeah, she'll eventually get sick of it, but it's new right now, so she's got to touch everything. Yes, that's how her shirt always gets wet, and that's why she always has to change her shirt, is because she'll put water in her mouth and she'll, spit it all out or let it dribble down her shirt every time. It's like a daily thing. I don't know why. There's just some things that are like kids are funny. However, okay, getting back into this. The way CNN said it or set up their story was that he was charging people thousands of dollars where it was literally like he was looking for donations and donors and backers of like corporations to get people out, not charging individuals. So that water cup, yeah, I love my Stanleys. I'm not gonna lie. The less I have to fill up with water cups during the day, the more water I'll drink. If I have to sit and refill a water cup every like hour, I get sick of it and I won't do it. But they basically accused him of extorting people and for money in order to get them out of the country, and that just wasn't true. So he did win a jury trial in January, but it never went to the penalty phase because CNN settled. So we don't exactly know how much they settled for. I would have really loved to see that, but the jury did find CNN guilty of defamation. I'm glad that CNN finally got held accountable. It doesn't seem like they learned anything. However, when other outlets were writing about this case, the AP picked up a story that basically accused him of the same thing. So they basically seemed like they were defaming him while they were writing about him winning a defamation suit, which was weird. And he sued a bunch of different outlets. So there was a lot of like back and forths of paperwork of just amended motions and withdrawal, like attorneys noticing like supplements to this notice of supplemental authority. There was just a bunch of like stuff that procedural stuff that like wasn't really juicy or important to talk about. So the life got busy, I got sidetracked, and I haven't paid attention to it in a while. Well, I've been checking dockets the last couple days, and I yeah, good point. And hey, just Jen, how are you? We seem to stumble upon. I looked at one case and I saw all of them were closed. All the cases were closed. And I'm like, oh. And then I looked at one case and it was a voluntarily dismissed. And I'm like, okay, this one's voluntarily dismissed. This one's voluntarily dismissed. What? I got to find the one that wasn't voluntarily dismissed. So here it is. There we go. There we go. All right. So this was filed 8/29 of 2025. So these are better. That's why I titled the stream Better Late Than Never, because just reading some of this, I was like, oh, and this is the same exact judge that handled his court case, like his trial. So this judge is very familiar with this entire situation. CNN is just as bad as UK BBC. I just think the media in general just sucks at their job. They are all for clicks and not for truth. They're the ultimate clickbait. And it's like, where do you think YouTubers learned how to clickbait? Mainstream media. So this was Zachary Young and his company, Nemix Enterprises, versus the Associated Press. Order on defendant's motion to dismiss or motion for summary judgment, plaintiff's amended motion for leave to amend, and defendant's motion to strike. There's a lot here. We'll kind of get into it. However, just some of the phrasing that the judge uses was like, it needs to be read in its entirety. Maybe the media needs to vet their shit before running the story. You'd almost think nobody vets anything these days. Nobody. And if they do, it's a rarity. If they say they vetted it, they're either lying to you or it's a very rare situation. This cause came before the court for hearing on July 3rd, 2025 on the Associated Press's motion to dismiss, or in the alternative, motion for summary judgment pursuant to Florida's anti-SLAPP statute. Oh, everybody's favorite word. And this does connect to another case that we're sort of talking about on this channel, where we're actually talking about a lot because there's always something new. And if we get through this, I'll kind of do the updates on that. There's really not a whole lot. Plaintiff's amended motion for leave to amend complaint and add claim for punitive damages filed May 22nd. And the Associated Press's motion to strike plaintiff's amended motion for leave to amend complaint and add claim for punitive damages filed May 27th. Responses, replies, supplemental evidence, supplemental authority were filed relative to all motions. Upon review of the amended motion to amend, it's like, how many times can you say amend in one sentence? The motion to strike, the responses, replies, supplemental evidence, and authority. After hearing oral argument and being otherwise fully advised in the premises, the court finds as follows. And I could never be a lawyer strictly for the amount of. My writing style is medical writing, and I say this often, but my style is medical writing. This person did this for this purpose. Patient did not comply with recommended, patient completed this, patient did this to reach this goal. Patient's BP this while doing activity. It's very short, cut and dry. This. There's no fluff. This is a lot of words for stuff that I would write in like 3 sentences. you know, yes, straight to the point. Time is money. They I had 5 minutes per hour to either type or go to the bathroom or both. Like, you didn't have time for shit. You had to get their time is money, is the more they write, the more money they make. It's just weird. Huh. Not so much judges, but you get my point. Introduction. It is said for some movies or television shows, sequels, spin-offs, or reboots should not be made. Oftentimes, the storyline is forced, new characters are not properly developed, inconsistencies arise between the original plot and the sequels, or the writers and producers are just lazy trying to cash in on a previously successful idea. These same things can be said of this case. I mean, really? The judge just told you that some sequels should not exist in your court case is that. Just starting off, if I were to read this first sentence, I was like, I don't need let's skip to the end. I don't need to read the other 16 pages. I think I know where this story is going. Previously, these same plaintiffs sued Cable News Network for defamation in this circuit, resulting in a jury trial in January 2025, with the jury finding that plaintiff Zachary Young was defamed by CNN, awarding him compensatory damages and determining that CNN was liable for punitive damages. The CNN case. And the footnote, the court used the same analogy in its order in the other case, or in another case. In that case was the sequel. This one would be the third installment of the Young CNN saga. I'm really getting sick of sagas. I don't know about y'all. As before, the court will leave the leave it to the Siskel's and Eberts, or the modern version of Rotten Tomatoes, to comment on which movies or shows were not well received by the audience and should not have been made. And I'm gonna see if I can upload that video because I have it on another profile in StreamYard. I just don't have it on this one, and I don't know why. But I'm I don't know. To me, this is just hilarious. To me, this is better than Belitho's, like, bring your checkbooks and shit. This case involves defendants reporting on the CNN case, and plaintiffs claim that the reporting, again, defamed them. However, upon parsing what plaintiffs allege was defamatory, the storyline is forced. Relative to their motion to amend, there is no substance to it. And at the end of the day, the lawsuit appears to be an attempt to repackage the CNN lawsuit to cash in again. For the reasons as will be explained below, defendants' motion to motion to dismiss, motion for summary judgment is due to be granted, and the motion to strike denied, and the amended motion to amend denied. Plaintiffs' claims in this case. In the complaint, plaintiffs allege causes of action for defamation per se, defamation by implication, and trade libel. These claims stem from reporting by David Bowder concerning the CNN case in one article published by defendant on January 17th, 2025. Plaintiff picks out one word or phrase, smuggle or helps smuggle people out of Afghanistan, to support their claims in this case. They allege that this accuses Young of committing a felony, which is a false accusation based on the court's ruling in the CNN case that Young did not do anything illegal, and therefore this is defamatory. Do we need a I don't know fun? We don't need this time we don't need a swear jar, at least. Oh. However, did anybody happen to watch the Fleabags the other day? I did not. I'm just asking this question to see if they got pissed at me, because if they didn't, we really need to work on that. Ugh. For the defamation by implication claim, plaintiff alleges that even if the use of the word smuggle did not literally call Young a criminal, the gist of the article implied he was one. Plaintiffs go on to allege that by choosing this loaded term and associating it with plaintiffs, defendant intentionally connected its report to CNN's portrayal of Mr. Young as a villain profiteer and even outdid CNN by explicitly suggesting criminal behavior. If you can outdo CNN with a level of bullshit, good luck, because that's a very hard thing to do. CNN has a very high bar for bullshit. The article. I don't have time to waste watching that shit. Neither do I, but that was the running joke in the chat the other day, was that they were gonna get pissed off and yell at me, or not yell at me. No one ever yells at me. I don't fucking care. But it was just funny. Someone was gonna watch the fleas and report back. Yeah, I was just curious. Oh. For purposes of this order, the court finds that it would be useful to include the text of the article, including the headline, for a complete understanding of the ruling and rationale. I really like this judge. I don't know if we will ever see a case from him again, but I really like him. I really enjoy watching him. This is the judge talking to the jury about what defamation actually is back in that CNN trial.
A statement is defamatory if it tends to harm plaintiff's reputation, tends to lower him in the estimation of the community, tends to expose him to hatred, ridicule, or contempt, tends to injure him in his business, reputation, or occupation, tends to deter third persons from associating or dealing with him, or charges that the plaintiff committed a crime. Not every unpleasant or uncomplimentary statement is defamatory. A statement is not defamatory merely because it is mean, embarrassing, or upsetting.
I will forever keep that as my Florida law definition of defamation from a judge. Plainly read out loud. Very chef's kiss on that one. Hi, Ricky Bobby. How are you? Squid smashed the super stickers and super chats. No way did she make your number. I don't know. It was just funny because I wasn't asking for super chats. I was simply making a comment. There are just some things when you are privileged enough to have a monetized stream or monetized videos, like when you only get a certain amount of super chats, like there are people who have streams who don't have anybody in them, who don't get any views on content. There are people who go streams without any super chats or gifted memberships. And I'm not saying me per se. I'm just saying in general. So like when you get super chats, don't bitch that you only had 10 super chats. Like what kind of entitlement bullshit is that? Like you make videos for a living. Yes, it's hard sometimes. Like I'm trying to film that video and I'm having to redo that video like 4 times because I'm not satisfied. However, like I said that the other day as like stop being greedy. Stop being a grifter. Like, if you really want super chats, like, do something else. Like, make some other content besides telling someone they're an awful person. Like, it's just one of those situations of, like, I didn't mean it to, like, use it as a grift. I was just pointing out that some people go entire streams without super chats. So, like, when you only get 10 super chats, just shut the fuck up. Like, wasn't grifting, but we went, nah, we gonna do what this good army do. Yeah. Well, that's I know my audience cares about me. I don't know what their audience cares about because I don't know. I don't know. However, it's one of those situations where it was like when you get only 10 super chats, like cross your lucky stars that you got 10. Go get a shirt. Go get a shirt out of your dresser. She managed to take off her shirt and get this, and I don't know how she got. Go get a shirt, Angel. Get a my topless wonder child. That's why I'm like, you stay over there till you get a shirt on. Yeah, 10 super chats, I would fall over. I don't. Can you get it? Your granddaughter took her shirt off and it's how many times can you repeat go get a dry shirt, go get a shirt out of your dresser before she'll actually do it? Ugh. All right. So I might have to go in a minute because she knows how to get a shirt out because she's done it before. She knows how to do it. It's just the want to. She doesn't want to. uh, yeah. Mama Squid just in time. Baby Squid took off her wet shirt. Yeah, she took off her wet shirt, but she refuses to get a dry one. Go get a dry shirt. Get a dry shirt. Then I will give you another one, but you need a shirt. And why do you have a scratch on your chest? Mama duties are calling. Somebody is not going to put a shirt on until they're forced to put a shirt on. So before she runs in back and I get in trouble for, by YouTube terms of service because I have a topless child running around, we're going to go get a shirt. I will be right back. Y'all take a break. I will be right back. Thanks for your cooperation. Good Lord. What a day. I love being a stay-at-home mom. I love it. I would not have it any other way. But sometimes things that are not that complicated turn out to be way, way more complicated than they should be. Like putting a shirt on. Way more complicated than it needs to be. Like, yeah, we're in the naked baby phase. Can you get a bowl, please? Yeah. There you go. You try. Okay. Oh, I just joined this room and thought you left. No, I didn't leave. The little at the beginning of the stream, she was playing with all my stuff back here, and she decided to spit water all over her shirt. And then instead of going to get me a new shirt, she just stripped off her shirt and was running around the house. And she wanted to change. There. She didn't want to get dressed. So I literally just chased her around the entire house with a dress. So if I seem out of breath, it's because I just literally sprinted across my entire house trying to chase a 3-year-old. Life is funny that way. We're in that phase. And before she ran behind me and YouTube got me for the child stuff because my child took off her own shirt, you know, I figured we'd like there's things that you never thought would be on your bingo card in 2025, but here we are. I don't know. I was the kid who would ask to go to bed. Like, can I go to sleep? Do I have to be awake now? Can I go to bed? And this kid will run all over my house at 9:30 at night. No. 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 Oh, hey, Robert, how are you? Hi, Squid, and all your friends. Just tell her she can't become a nudist until you are 60. Oh, my goodness. All right, let's get back into this. For those of you just joining, this is Zachary Young won a jury trial against CNN in January of 2025 for defamation and proceeded to sue the Associated Press and a bunch of other news outlets who wrote on the story and then picked up the story and republished it. And this is the judge's order dismissing that case. As stating, this is the sequel that nobody asked for. So this is the headline and the article that is being talked about. Florida jury says CNN defamed Navy veteran in story about endangered Afghans. After a Florida jury found that CNN defamed a U.S. Navy veteran who helped rescue endangered Afghans, the network reached a settlement on Friday to avoid a punishing order that it pay punitive damages. I really, really, really wish it would have went to the punitive damages phase because I want to see what a jury would have, a Florida jury at that, would have made CNN pay. The unusual ruling against a media outlet following a jury defamation trial was a blow to both struggling CNN and news outlets in general on the eve of a new term as president by Donald Trump, who has whipped up anger against journalists amongst his supporters. I have so many issues with this article just based on the fact that, like, them defaming or not defaming or writing an article about the Afghanistan withdrawal and Zachary Young has nothing to do with Trump. And the vitriol against the media has to do with them lying to the public, not Trump. So, like, the TDS is shining brightly through this. Social worker told me the problem you have with toddlers are basically what you will deal with when they are teens. Yeah, I'm convinced a 3-year-old and a 13-year-old are the same. The same in a. Here's what I mean by that. They both are in the boundary pushing phase. Just a 3-year-old doesn't know any better. A 13-year-old kind of should know better. I bet we would get less. Jesus. Yes, of course they have to mention Trump. And that's my thing. It's like people bringing up, like, I have no problem if you hate Donald Trump or you love Donald Trump. I don't care either way. That's your business. But when people bring up Trump in something that has nothing to do with politics, that's when I'm like, you got issues, bro. You got issues. Like, you got issues. Squid, don't you realize it's the thing to blame everything on politics or Jeremy Hills? Yeah, that's true. Okay, 3-year-olds and teens need your help. They will bite your head off when you help. True. Are you saying you're the same as a 3-year-old and a 13-year-old? Yeah, and that's the thing that I don't understand. Like, I don't understand this about a lot of people because I joke that I have paint colors. Like, I changed my paint colors. Now I want, like, Lucky Charms blue. Um, when I redecorate my apartment that I have in some people's heads, I have no idea why people let other people, especially people who don't even know they exist or care that they exist, bother them so much. Like, and I don't understand how you wake up so angry every day. It's just weird. It's just bizarre. So, like, to bring up, like, I know they did that for clicks, or I think they did that for clicks, and that's why people hate journalists. You bring up shit that has nothing to do. Yeah, the other day, like, um, I always get the littlest sweet. Um, and this time I picked up a bag of Lucky Charms marshmallows. So it's like it's the blue from the moon in the Lucky Charms box. So, I always joke that I have paint colors picked out so I can redecorate the apartments I have in people's heads. I just don't like I don't get it. The jury in Panama City, Florida, ruled in favor of Zachary Young following more than 8 hours of deliberation in a trial of less than 2 weeks. Young blamed CNN for destroying his business through a 2021 story on Jake Tapper's broadcast about black market of extracting desperate Afghans following the Taliban takeover. I know Zach feels heard in a way that he hasn't felt for over 3 years, said Kyle Roach, one of his lawyers, after the verdict. The jury awarded Young $5 million in compensatory damages. That is why I wanted to see what they would have done for punitive damages, because $5 million was compensatory. What would they have done to CNN in Florida for punitive damages? So funny. Yeah, well, your boss is also a fucking dumbass. Like the very definition of a Cuntosaurus Rex. Just saying. And I have no problem with telling that to that bitch's face. And if I didn't want to dox where you worked, I'd put that bitch's face all over the fucking internet. Right before I sue her. Speaking of that, Mom, have you talked to a lawyer yet? Everybody encouraged my mom to seek an employment lawyer because her boss is a fucking bitch. By the way. And you probably have a couple more cases against, for like workman's comp and shit too. By the way. A second phase of the trial to award punitive damages was underway Friday afternoon before Circuit Court Judge William S. Henry interrupted proceedings to announce a settlement. Terms were not disclosed. We remain proud of our journalists. I'm clutching my imaginary pearls. Hey, Malin. We remain proud of our journalists and are 100% committed to strong, fearless, and fair-minded reporting at CNN. If that ain't the most loaded bunch of bullshit I've ever fucking heard. Though we will, of course, take what useful lessons we can from this case, CNN had said in a statement. You didn't learn anything from, like, the Nicholas Sandman incident. CNN never learned anything. Stop. We're just gonna cut that shit right now. No. Young's business helped smuggle people out of Afghanistan, but he said he worked exclusively with deep pocket outside business or outside sponsors like Bloomberg and Audible. CNN showed his face in a story that primarily raised questions about contractors who were charging Afghans themselves fees as much as $10,000 to get out. And as much as I like this this judge and the way he writes, this is the actual article. That right there is like, to me, is like pushing the boundaries of your right as a journalist. Like, I don't know. He testified that the term black market implied he was involved in something illegal. It's devastating if you're labeled a criminal all over the world. He testified during a trial, especially if you're working with like Audible and Bloomberg. I mean, to be labeled a criminal and then like expecting those businesses to give you money. I can see where he's coming from. CNN contended its reporting was fair and accurate, although the network did issue a statement a few months after the story aired apologizing for using the phrase black market. And I can totally see if CNN was reporting that story, but like vet that story. And when you have people that you're going to show their face on your network that aren't that story, it's one of the reasons that, I mean, as stupid as it sounds, I hate talking about multiple topics on one stream because of the fact that I don't want things to get misconstrued and like people to get confused between stories, because there's a lot going on in some of these cases, as we've seen with like the Hales case. Things get mixed up very easily, and I don't want details of different cases to get mixed up, let alone different, like, you get Hales cases mixed up, but it's all Hales at the end of the day. I don't want you to get Hales mixed up with like Zachary Young or Owens or Schultz. Details to get. It's one of the reasons I don't like doing like just news shows about like different topics, or talking about different cases in one show. If we're doing a deep dive like this, because I don't want people to get misconstrued. And it's like CNN literally put his face. They might have been talking about black market people. But when you talk about black market issues and then put someone's face on your network who's doing something legally, it's like those two aren't the same thing. I believe the only true news outlet is the AP because they usually vet their sources. Yeah, but if you ever watch Shizzy in the morning, I know a lot of times at night Shizzy does the drama streams, the dramatic letters, the what the hell stuff, all that. But if you watch him in the morning, he will read AP articles. Oh, I don't know if they're all AP, but he will read some articles from the AP. And like you can just see their bias written right into the article. Like they don't even try to hide that shit. So I'm like, to me, the only true news outlet is you reading multiple sources of the same article, or the same topic. And like we used to do, when I used to do political streams, we'd find a hot topic and we would read the same topic with articles from Fox News, the AP, CNN, Yahoo, and try to put the pieces together and get a complete story. Because there is no such thing as everybody's got a fucking spin these days. So, I don't think there is a true news outlet. I think everything is, they only tell you what they want you to hear. They don't give you the whole story. At a trial located in a conservative part of the country. Like this may not be defamatory, but this is just shitty writing. This, you can see the bias just leaking through. Young's lawyers urged jurors to send a message to the media. Questions submitted by jurors during the trial telegraphed some hostility, with one wondering whether CNN had treated the plaintiff as guilty until proven innocent. That's a valid question, because we've seen it in the media. We've seen it. The jury of public opinion seems to mean more than what the judge says or what the jury says. We saw it in Kenosha kid, Kyle, whatever his name is. I'm at a loss right now. You see guilty until proven innocent because people put in the media false information all the time, and people actually believe this. There are people who believe everything they see on the internet. I like to read the documents of things because I don't want to be one of those people who people say, well, Squid said this. I want the people to go, well, Squid said this because she read the actual document from the judge. You know, can I turn on my blue light lamp? It's right here. It's green right now. Hold on. There you go. There's blue. Did you see the dash cam video of the UPS plane? Yes, I did, and I will be reading that NTSB report when it comes out. As we all know, I have a history of aviation. Mr. Squid currently works in aviation. I have friends in aviation. So it's I will be reading that NTSB report. Probably not with Spawn. Maybe with Spawn, but probably not because he's kind of over the whole aviation and all the shit going on right now. So I'll have to see if he wants to read it with me, but I will be, at least with myself, reading it. So it's a shame that video proof is no longer proper documentation because it's ridiculous that people believe everything is doctored. Yeah, and I know that some things are doctored, but it's like, yeah, Kyle Rittenhouse, thank you. I'm just having I lived there at the time. Like, I didn't live in Kenosha, but I lived in Milwaukee County at the time. I moved right after that. So when people here would ask me where I was from, I was like, you know where Kyle Rittenhouse is? I'm like, I was like 30 minutes north of that. Yeah. But people believe what they want to believe. People don't believe the facts. So I like to read the documents from the courts because that's what actually matters, what people report. And even people that report on the documents in the mainstream media, they only report a quarter. Even it doesn't matter what side of the aisle you're on. Like I did that Jeffrey Epstein stuff a couple weeks ago. Or maybe that was like a month ago now. Geez, the time is flying. We actually read the documents from the judge because you hear liberals say one thing, you hear conservatives say one. Well, what's the actual fucking truth? It's somewhere in the fucking middle. It's never. Everybody wants things to be black and white, yes or no, and we don't live in a black and white world. We live in a gray area. Everything is somewhere in the middle. Yep, yeah, I really like that blue light when it falls on Squid. Yeah, it's here. It's here. I mean, it's all sorts of colors. That was one of my Amazon Prime Day purchases. Conspiracy theory is taken over for truth, just like certain cases where proper receipts are still not taken as proof. Yeah. Oh, speaking of conspiracy theories and stuff like that, I have all the documents from the Charlie Kirk case that I still need to get into. We're slowly trying to get back into like a regular thing of not talking about Hales every day. It's hard because there's so much stuff to talk about, and if you miss some stuff, you get so behind. So, yeah. All right. Private messages also became part of the trial, with plaintiffs showing internal messages where CNN reporter Alex Marquardt said some profane and unflattering things about Young. Marquardt testified in the trial that his story, which aired on November 11th, 2021, interesting that it's a Navy vet and they aired it on Veterans Day. Coincidence? I think not. That's my conspiracy, that they did that shit on purpose. And was followed up with print pieces on CNN's website. Was not a hit piece. Honestly, Mom, I have no idea where that's at. It's somewhere in the attic. I don't know. It's got a... There you go. I don't quite have that like completely red, I look like the devil background like Biden did in that one speech, but yeah. Yeah, it's difficult because crap breaks off of us every day. Trying to cover multiple topics are difficult. Yeah. Well, this is from August, because I got so behind on this that I just forgot. And I've been meaning to check it for days and then just didn't. And when I did, it was like, oh shit, we have to talk about this week. Ah, you don't have to turn the red light on. Those days are over. Oh, I love this chat. Uh, for at times that red light would be very appropriate. We would know baby squid is getting changed. Ah. All right. Defamation trials are actually rare in the United States, in part because strong constitutional protections for the press, making proving liable difficult. News outlets with qualms about their cases often seek settlements before taking the risks of bringing it before a judge or jury. Not this time. And you've seen CNN settle. I mean, they settled with Sandman. I'm sure I've heard, and I don't remember exactly, they settled with Kyle Rittenhouse. They settled with a bunch of other people. Yeah. They didn't settle here and they got screwed. The jurors didn't appear upset about the idea of missing the extra step as he announced the settlement. Henry read an earlier note from the jurors saying, "Did you forget about us? It's 5 o'clock somewhere," drawing laughter. Defendant's motion to dismiss / motion for summary judgment. In the motions, defendant argues that plaintiff's lawsuit is barred by Florida's anti-SLAPP statute, 768.295. Further, defendant asserts that the article is not reasonably capable of defamatory, meaning it's protected by the fair report privileges. Finally, defendant argues that Nemec's trade libel claim fails because it was not of and concerning Nemec's. As a result, defendant requests that the amended complaint be dismissed with prejudice. Plaintiff's amended motion to amend. In the amended motion to amend, footnote 3, plaintiffs seek leave to plead punitive damages in this case, arguing that the article itself, when put in context with the filings in the CNN case, and defendant's refusal to retract the article, demonstrate actual malice. The amended motion to amend is not supported by the normal submission of evidence or proffer of evidence as contemplated by 768.72 Florida statutes. In essence, the amended motion to amend relies on the article published by defendant and the surrounding circumstances to demonstrate the conduct to support the punitive damages claim. Based on this record, plaintiffs request leave to assert a claim for punitive damages as pled in the proposed amended complaint. I just have to go check on my child because she got really quiet and I need to make sure that she put her stuff away, if you know what I mean. So I will be back in a hot minute. No red lights here. Just a toddler with sugar. All right. Yeah, baby squid break. Be right back. So she got a bowl and she dumped only a few in there. I'm surprised, but she still had the bag in front of her. And I'm like, before she eats every single one of these marshmallows, I need to go put them away. So, see, we need a baby squid GoPro. No. Over here in Sweden, our red light is called the Happy Street. Interesting. Wait, they are saying the First Amendment is a liability. They're saying who the plaintiffs or the defendants, because he keeps switching back and forth between both of them in this one. Defendant's motion to strike. Defendant moved to strike the plaintiff's amended motion to amend, arguing that the original motion to amend filed by plaintiffs contained non-existent case citations. Interesting. In addition to striking the motion, defendants sought relief by requiring plaintiffs to seek leave of court, which would include an explanation for the fake authorities before filing another motion to amend, and to require plaintiffs to include a certification in any other filings as to the citations or quotations used. That's an interesting paragraph. I'm sorry. That was like fake citations. Where have we seen that before? And I don't know if that's accurate. I did not read the motion with all of the citations and look all of them up. Motion to dismiss, fair report privilege. For the most part, defendant is entitled to dismissal of or summary judgment on plaintiff's claim, in this case, premised on the fair report privileges. In Florida, the fair report privilege grants journalists and news media a qualified privilege to report on information received from government officials or to publish the contents of official documents as long as the account is reasonably accurate and fair. See, that's very, subjective. That's very subjective to me. I don't know, this is deliberately confusing. Yeah, I just don't like that this judge is switching back and forth. I overall like this judge and the way he writes. However, I just don't like that he's going back and forth between defendants, plaintiff, defendant, plaintiff, defendant, plaintiff. Uh-oh. Angel, you want this water? Don't you have water out there? If you spit that water out, you're going to be wearing a wet dress for today. I wonder why these scandal news outlets don't get sued more often, because that's their selling point, is false stories. Yeah, I don't know. To qualify as reasonably accurate and fair, the publication must be a substantially correct account of information contained in all public records or derived from a government source. That implies that the government is accurate and truthful, which I happen to know from being an employee of the government for a while, that that's not always the case. Just a thought. Footnote 2, defendant couched its motion as either a motion to dismiss or, because of the Florida Anti-SLAPP statute, which authorizes an early determination, a motion for summary judgment. Both sides submitted documentation outside the four corners of the complaint in support of and as opposition to the motion to dismiss. Procedurally, the motion to dismiss was compliant with Rule 1.510, or any timing issues were otherwise waived by the parties. Therefore, the court will treat the motion to dismiss more as a motion for summary judgment, since both sides invited, encouraged, and supplied the court with evidence. I'm assuming that's supposed to be with, and I really hate judges that, I really hate all people who have a degree beyond a bachelor's degree. You have a very high degree and you can't proofread or use Grammarly. Something. With evidence outside the complaint, in this case for consideration. And footnote 3, plaintiffs originally filed a motion to amend on April 14th, 2025. After defense counsel contacted plaintiffs' counsel regarding certain phantom citations to non-existent cases or quotes from cases contained within the motion, plaintiffs essentially withdrew the original motion to amend, deleted the hallucinatory citations in the filing, and amended the motion, and went forward with the hearing on the amended motion. And I think he has different attorneys in this case than he had the first time. He's it's just weird. I just sometimes you just like you have a thought about something, but it's not YouTube appropriate. So you just gotta bite your tongue and just wait till that thought passes before you can speak again. What the actual fuck? If you are bringing a motion, or if you, I say the same thing about every attorney who brings a case that I've seen. I don't discriminate. I hate everybody equally. I don't I'm hard on everybody because y'all are supposed to be smarter than us and held to a higher standard. So I'm holding you to that higher standard. What the hell is with this non-existent cases and hallucinatory citations? What the actual fuck? Sorry. What the actual fuck? I mean, aren't y'all like no. Ah, mm. Determination of whether a privilege has been established is a question of law. See, who's R.V. Gross, Florida First District Court of Appeals, 1985. Reporting on a lawsuit falls within the category of official action to which the fair reporting privilege applies. There is qualified privilege which applies to the judicial and quasi-judicial proceedings so long as they are accurate, fair, and impartial. The privilege has been applied in situations in which a media defendant has republished a defamatory statement made by another person, where the making of the statement itself was a newsworthy event. Trump Media and Technology Group Corp. VWP Company LLC, Middle District of Florida, 2024. I have a big problem with this because it seems like it's CNN they have the problem with when it's so many news outlets to do the same thing but never get sued for millions. Yeah. It and these people, the AP, were writing about the CNN trial. So it was like I don't know. It's so weird. Squid, who's his lawyer now? I honestly don't. I don't know who these lawyers are. I've never heard of them. I've never seen them. But I believe they're different than his original trial lawyers. Hmm. For the fair reporting privilege to apply, the news report need not contain each and every fact or be presented from a neutral perspective. There's my problem. If I have no problem with an opinion piece if it's labeled as a freaking opinion piece. It's when people write opinion pieces and try to pass them off as journalism. It's not the ugh, it, I watch YouTube, my TV listens. If I type something on my phone, I get all kinds of media stories. Yeah, welcome to 2025 and your phone listens all the time. It's I can't blame an entire company when the news reporter is the one who reported it. Yes and yes and no. I have there's a thing about that. Like when you like the Maya Kowalski case, for example, it's the hospital that got sued because of the actions of the employees. When you are an employee of a company, you represent that company. It's why companies really need to work on their damn hiring practices and not hire shitty employees. Because when you are an employee, you are a representation of that company. So yes, it might be your personal actions, but when you are acting in an official capacity, you are representing that company. So that company is liable because they hired you. Is the best way I can kind of put that. There lies the issue in comparison. CNN case was claims that were false, whereas the case was citing the CNN report. That's why the recent case fails. True. What are editors these days? In general, I see you got your desk built. Yes, I did. I was up till midnight last night, and I got up at 5 o'clock this morning. So if I'm a little exhausted, I am. The fair reporting privilege applies even if some of the published information may have been phrased to catch the readership's attention. It's a very interesting way of putting that. What is more, the privilege applies even when the reporting omits pertinent information. That's my other problem with journalists, quote unquote, these days, is they only tell you what they want you to hear. They don't give you a well-rounded picture of what happened, which is why I feel the need to Google and look at the same topic in 4-ish different publications to see an entire picture, not just what I want to hear. Because the Republicans always go to Fox News to get what they want, the side that they want to hear and the perspectives that they want to hear. The liberals always go to CNN, MSDNC, all them things to get the perspective that they want to hear. We have a very bad time with an echo chamber and hearing people you disagree with or getting all the information, because there's a good chance that in a situation you're not going to agree on everything that happened, but you need all the facts to make an informed decision, and we don't get all the facts ever. Example, news. Yes, plane crashed in Kentucky. Yes. Three aboard perished. Holding that fair reporting privilege applied even though the report did not reveal other exculpatory, I can say that word, but it never flows in a sentence. Exculpatory information. Citing another case, Telemundo, explaining the fair reporting privilege does not dictate that news organizations report on the contents of official files in sterile language, and that the media is free to select the focus of its reporting without losing the protection of the fair report privilege. Putting all of these things together, the fair reporting privilege applies where the news media reports on a pending lawsuit or case, and the information contained in the story is substantially correct and accurate account of the court record and events. The reporting does not need to include all the facts, can omit pertinent or exculpatory information, and can come from a biased point of view, even phrasing some of the commentary to catch the reader's attention. Based upon a review of the article, it is substantially correct account of what transpired in the CNN case. And remember, the judge who's writing this was the same judge who presided over the CNN case. So if anybody knows all of the details of the CNN case, it is him. Plaintiffs argue that defendant went beyond fair reporting by injecting the phrase, quote, helped smuggle people out of Afghanistan, which was not part of any official record or courtroom proceedings. However, plaintiffs missed the point on this. What was part of the court proceedings was Young's description of how evacuation services for Afghans were performed. Young himself was never located in Afghanistan, but he instead had a contact that he used to arrange, coordinate, and plan evacuation services. He used, and then turned his contact used, encrypted communications with operatives on the ground, which communications were not preserved to protect operational safety. Young only knew one person who was his contact and did not even know who the operatives on the ground were, again for operational safety. Once contact was made with the evacuees, the operatives would move them covertly to safe houses to avoid detection by the Taliban. At times, the extraction was delayed to maintain the safety of the evacuees and operatives. Then once the evacuation could be completed safely, the operatives would move the evacuee across the border. Footnote 4, unlike the decisions in the Grayson case, where the courts held that there were no allegations that the defendants were members of the media or journalists, and therefore the fair report privilege did not apply, plaintiff's complaint alleges that defendant is a news organization. Here's my $1 million question, and I don't know the answer to this. Of course, you guys know I brainstorm with you guys, and things just come to my head when we're talking that upon reflection later I might have an answer to, and sometimes I never get an answer. What constitutes a journalist? Do you have to work for a mainstream media outlet to do it? Or will, like, Megan's a journalist. Does her writing make her a journalist? Possibly. Does her reporting on things make her a journalist? Her FOIA requests make her a journalist? Yes. However, if someone who is not, but she doesn't have a journalism degree. A lot of people with journalism degrees would bitch, wrongly so in my opinion, that not a journalist. Doesn't work for a major news outlet, not a journalist. However, does writing a Medium article make you a journalist? Does investigating a topic and reporting on it on a YouTube channel make you a journalist? What constitutes a journalist that would be covered by the fair report privilege? I don't know what exactly the fair report privilege says word for word in that statute. I haven't read it. I probably will because I'm curious. However, hey, it's Hines. Hey, Squid, can't stay long, but thanks for tuning into my stream. I have been wanting to message you, but my Discord was hacked. Of course. You can email me. Can somebody well, hold on, let me screenshot my email or that email so I don't forget. Yeah, I've been meaning I have to update some stuff for you. That we were working on before. I was putting together my setup this morning, so I had you on my phone and it was quite nice to listen to. But I loved the guest you had on this morning. I love her. But I take exception because she was like she was talking about something and she was like, everybody seems so prepared and here I am just like, hi guys, how you doing today? And I'm like, you can't take my title of the biggest hot mess on YouTube. Like, you can't do it. You can't do it. Oh, but it's good to see you. Yeah, everyone is considered an independent journalist today, but what constitutes an independent journalist for the fair report privilege in Florida? Kind of a situation. And Devilman Squid, sorry to change topics, but do you know if they have the black box in the crash yet? They do. They do. I heard it was possibly damaged by fire, but we'll see. But I will be reading the thanks for reminding me that I have to check the NTSB's website for final reports on a couple of things because it's been about 6 months since the initial reports. So, I have some hope that maybe some final reports are done. Yeah. I'd love to email you about this exact topic. It's an entire stream. Email me. If anybody wants to throw my email in the chat, that would be great. Because email me. If I don't get back to you immediately, if I don't get back to you an email immediately, trust me, I read it. Sometimes I'm really bad, and if I don't get back to you within like 48 hours, just email me again and just say, "Hey, remember me." Because sometimes I'm that type of person where I'll read it and I'll say, "Okay, I'll do that," but if I didn't write it down, fucking forget. My inbox right now has 548 emails. So, uh so my email is here, I'll write it down. There we go. All right. Oh, yes, and if you Gail just mentioned, if you have not subscribed to my new channel, go do it. It's a kick-ass new ride. She has found her niche. My niche is my college degree. That's what I was supposed to have a video up yesterday. I recorded it, started editing it, and was just not satisfied with the audio and went to fix a bunch of stuff. Went to Chat GPT and asked a bunch of questions on settings. And I'm a perfectionist, so I have to get used to the fact that at the beginning it's not going to be perfect because I do not record a lot of videos. I do live streams. Big difference between live streams and a recorded video. So with that, I have to get used to the fact that things are not going to be perfect in the beginning. So if you see me delayed or frustrated, that's why. Because I am not satisfied. All right. Getting back into this. So we got a ways to go and only about a half an hour left. In the preceding paragraph, the court used 124 words to describe the testimony that Young himself provided in the CNN case. To the average reasonable reader, those same 124 words can be summarized with the 8-word phrase, Young's business helped smuggle people out of Afghanistan. When put into the context of the preceding sentences, that described how Young helped endangered and desperate Afghans escape the Taliban. Yeah, I don't necessarily agree with the judge in that context, but maybe the average person does, and maybe I'm just not average. I don't know. Have a good rest of your day. Even when the publication arguably impugns or accuses a person of criminal wrongdoing, the fair report privilege would apply to bar a defamation claim. For instance, this case from 2006, the court held that reporting fairly and accurately described a matter of public record, including the criminal information, the governor's executive orders appointing a special prosecutor, Mr. Rasmussen's information or plea agreements, and reports by government officials that he pled guilty to related charges. I hate the word pleaded. Sorry. You'll always see me say pled. For some reason the word pleaded, it just sounds so wrong to me. To the public corruption charges when the state had dropped those charges. As such, his claim was barred. This case was really no different than Husar, another one. The article was reporting on a lawsuit between plaintiffs and CNN. While the article may not have contained each and every detail of the court proceedings, it presented a reasonably accurate account of the basis for the outcome of the CNN case. And even though plaintiffs claimed that defendant inserted an accusation of smuggling to compound the wrong committed by CNN, the use of such word in the context of the story was not defamatory, such that the fair report privilege still bars their claims. Sometimes I don't know if I like this fair report privilege sometimes like I get it. To agree with something, I don't always have to like it. Angel. Hi, beautiful. There's baby hands right there. Oh. Mommy. Angel. Somebody clip that. Yeah. So just know to the fact that I don't always have to like something to agree with it. Sometimes in other cases that you've seen me cover, I don't have to like something. Oh yeah. Woo, girl. Hold on. Oh. Mama duties ensue. Somebody has a dirty yeah. The problem with everyone with a phone thinks they're a reporter. And yeah, it's like, what's the line? It's where is the line? There's the $1 million question. I will be right back. I have to change a you know, we have to do be right back, y'all. And I don't have the video updated yet, so we will have to do this one.
Guys, I'm here.
I've been replaced. You know, I've been replaced. I don't know what to tell y'all. Don't scream though. It hurts people's ears.
Hi guys. I would say
Yep. New
Yep.
host.
those.
Nana says cupcake. No, please don't mess with my settings. Mama worked hard to change those. And Jeffrey, I will be uploading it again. I just have to oh, bye. Okay, bye. Bye. She's mad because I moved her. I will be uploading it again. It's on one. Since I've been upping my game, there's different. YouTube has different. Not YouTube. StreamYard has different things. It's on my main one. It's just not on my document reading one. I have different profiles. So different brands. So I don't have it on that specific one. And unfortunately, those don't carry over. So, I'm working on it though. Oh, Megan. So, uh, if sorry, I scrolled back up. And hey, Kevin. Yeah, she's she's something else. I love her so much. Sometimes I'm like, girl, you're a lot. All right. While the fair report privilege would bar plaintiff's claims in this case, the court would additionally address specific items that demonstrate why plaintiff's complaint is subject to dismissal and or summary judgment. When a statement charges a person with committing a crime, the statement is considered defamation per se. Publications which impute to another characteristics or conditions incompatible with the proper exercise of one's business, trade, or profession or office are slanderous per se. Plaintiffs point to the phrase helped smuggle people out of Afghanistan, and specifically the word smuggle, to allege that defendant was responsible for defamation per se against Young, since it accused him of committing a felony. Additionally, he relies on the ruling in the CNN case where the court found that Young had not committed a crime to demonstrate the falsity of this accusation. Whether a statement is defamatory or not is a question of law. So this is his basic speech that I read to you guys, or I showed you the video of. Whether a statement is defamatory or not is a question of law. When making this assessment, a court should construe statements in their totality with attention given to any cautionary terms used by the publisher in qualifying the statement. Where facts are not in dispute in defamation cases, however, pretrial dispositions are especially appropriate because of the chilling effect these cases have on the freedom of speech. Thus, courts routinely dismiss defamation claims at the motion to dismiss stage. There are multitude of cases where charged language was found to be non-actionable, rhetorical hyperbole, vigorous epithet, exaggeration, or figurative use of terminology for dramatic effect. Whole bunch of cases. In these cases, the court applied the proper analysis of looking at the use of the inflammatory terminology in the context of the entirety of the publication as opposed to just the specific word, phrase, or sentence. And in some, the courts determined that the expression was demonstrably true from the facts stated within the publication. Therefore, the court determined as a matter of law that the accusations were non-actionable opinions. Plaintiff points to the AP Style Book, Black's Law Dictionary, and other dictionary definitions for the meaning of the word smuggle to justify the claim that this was defamatory. While defining a particular word is helpful, one must also look to the context for how it was used. It's one of those things for when things are taken out of context, it matters. It's so when you say stuff or you take a 30-second clip of somebody in the span of an hour-long interview or discussion, it's like shit don't matter. 30 seconds of an hour doesn't matter. To be clear, the ruling on partial summary judgment in the CNN case was based on the record where CNN's corporate representative acknowledged that its reporting did not uncover illegal or criminal activity committed by Young. There was no dispute as to material fact that Young did not act illegally or criminally. However, this ruling is not binding on defendant in this instant case. The prerequisites for res judica are not satisfied, requiring a judgment on the merits and identity of things sued for, cause of action, persons and parties to the action, and quality or capacity of the persons for or against whom the claim is made. Nor does the collateral estoppel apply. I really don't like that this judge doesn't use double-spaced. It makes it especially hard to read, and it's a lot to read. My opinion is that corruption we are seeing everywhere now would have been just ignored if it was not independent journalists putting light on it. Yeah. And I don't know. Some people have called me a journalist, and I'm like, am I really though? And this is the a debate that people can have because, it. Hmm, hmm, hmm. Someone just discussed in regards to the Kamala Harris interview and noted that the person who cut that up and strung it back together deserves an Emmy Award for making the original coherent. I didn't see any of it, didn't pay attention to it, but same can be. It's any interview where you can see the cuts, I have a problem with. Because it was like, what did the original look like? And that could be for good or for bad. All right. Nor does collateral estoppel apply, stating that collateral estoppel bars relitigation of the same issue between the same parties previously determined by a valid judgment. Clearly, CNN and defendant are different entities, so neither principle would bar defendant from trying to contest that Young acted illegally or criminally if it chose to do so. For instance, in this case, the court addressed the use of the phrase, Pullum is pushing drugs. I mean, he's a drug pusher, trying to push drugs, trying to get liquor, drink and sell liquor and all. Even though the trial court in that case found the term drug pusher used by Johnson clearly denotes an everyday meaning, a person who sells or distributes drugs illegally, the court stated that it had to read and construe the publication in its full context, deriving its meaning and significance from that instead of simply looking at the offending words. Citing a whole bunch of other cases, when construed in context, the court found that the challenged drug pusher statement cannot reasonably be interpreted as stating actual facts about Pullum's illegal association with drugs and therefore was not defamatory. In this instant case, the same is true. Out of the gate, the headline frames Young and his claim against CNN in a positive light. Florida jury says CNN defamed Navy veteran. I don't really fucking hate that they don't capitalize. What if I'm being facetious. In a story about endangered Afghans. The body of the article starts with a laudatory statement of who Young was and what he did. U.S. Navy veteran who helped rescue endangered Afghans. It then explained that Young got a favorable outcome against CNN for destroying his business through a 2021 story on Jake Tapper's broadcast about black market of extracting desperate Afghans following the Taliban takeover. I wouldn't exactly call it that, but splitting hairs at this point. Construing this last sentence, it would be obvious to an average reader that CNN was found to be wrong for using the term black market, essentially accusing him of criminal or illegal behavior. Similarly, defendant had already, within the first 4 sentences of the article, demonstrated how Young was in the business of helping endangered and desperate Afghans. Turning to the paragraph where smuggle is used, the rest of that paragraph explains how Young was hired by companies, but how CNN used his face in a story about contractors directly charging Afghans. In essence, this one paragraph summarized the issue in the CNN case, that Young's image and name were used and juxtaposed in an improper manner where he did not fit the narrative of the subject of the piece, that being that bad actors were preying on individual Afghans. And that's my problem with that too, is like they might have had an accurate story in the sense of like, yes, people were actually doing that to innocent people. However, putting his name and his image and using his likeness to justify that is defamatory. Red light time. Nah. When read in context, the use of the word smuggle or phrase helped smuggle people out of Afghanistan is not and cannot be construed to connote defamation per se. Smuggle was used to describe Young's work to rescue endangered and desperate Afghans. See, I didn't read it like that. I read it as smuggle as like illegal. The antithesis of accusing him of a crime. As such, these words and phrases objectively do not charge Young with a commission of a crime, nor impugn Young in the exercise of his business, trade, or profession. Rather, when read in context, it describes the benefit he provided and why he sued CNN. A simple analogous used in the words of the word smuggle can easily demonstrate how context matters. If one simply accused John of smuggling, he could claim that he was defamed. However, if it is explained that John smuggled a candy bar into the movie theater by secreting it in his backpack instead of buying candy from the concession stand, no reasonable reader would believe that John committed a crime. That's a very simple analogy, but okay. The same is true from the context of how smuggle is used in the article to summarily describe Young's rescue efforts, which is the furthest thing from human smuggling, as plaintiffs posit in this case. Ain't that the truth? Applying the above principles, there's nothing in the article that's defamatory per se. The use of the word smuggle does not constitute defamation per se when viewed in the context of which it was used. Therefore, as a matter of law, the court determines that count 1 for defamation per se should be dismissed and summary judgment granted in favor of defendant. Defamation by implication, talking about his business. Young again relies on the word smuggle. This is an implication that he was a villain profiteer guilty of wrongdoing despite his claims to the contrary. In addition, Young accuses defendant of omitting or downplaying crucial facts from the CNN case that would dispel the notion of illegality. By doing so, Young opines that defendant created a sly implication that even if he didn't charge the Afghans, he still engaged in unlawful smuggling enterprise funded by others, suggesting Mr. Young orchestrated a criminal venture behind a veneer of philanthropy. In this manner, defendant allegedly defamed him by implication. I just finished rebuilding and editing my email accounts on the desktop computer. Everything is back to normal and synced with my laptop. About damn time. Not from your take, but technology is good until it's not. Defamation by implication applies in circumstances where literally true statements are conveyed in such ways as to create a false impression, or where the defendant juxtaposes a series of facts as to imply a defamatory connection between them. Where have we seen that? Or create a defamatory implication by omitting facts. Internal quotation marks omitted. However, the facts that plaintiff may not like the way the article was written or what it says about them does not automatically provide the basis for a libel suit. As discussed above, the article contains an accurate recitation of the CNN case. The implication that Young seeks to create in this case does not exist when reading the full article. Maybe I just had a problem with the article in general, the way that it was written. I just found it very, bringing up politics. Maybe I just had a problem with the fact of the article in general. I don't know. Because when I read it, I was like, this is a shitty article. And I agreed with the fact that I thought it was defamation because of the word smuggle. But I also, when I hear smuggle, I think illegal. So I had a problem with the article. But maybe reading it again, when I read it the first time, I had a problem with the article as a whole because the writer just seemed like a TDS, brain infected, has to bring politics into places where politics are not you have to bring Trump and politics into everything, even when they're not warranted. And I have a problem with that. Hey, Taz. I don't know. The implication that Young seeks to create in this case does not exist when reading the full article and examining the words in context. In fact, the article includes a quote from Young's attorney demonstrating his relief and appreciation in the outcome of the CNN case, and a quote from Young's trial testimony about how devastating CNN's black market implication was. If anything, the overall gist of the article was the reputation of a Navy veteran who rescued and saved Afghans from the Taliban, was vindicated after CNN defamed him. I don't see it the same way as this judge, but fair enough. Oop. The article's use of the word smuggle does not create a false impression. To me it did, but once again, to me it did. Like I said, I don't have to like something to agree with it. And unlike the CNN piece, there was no juxtaposition of facts to create a false narrative. While there is information from the case that may have been omitted, the omissions do not create a defamatory implication. Accordingly, as a matter of law, the court finds that this article does not support a claim for defamation by implication, and dismissal or summary judgment in favor of defendant on count 1 is appropriate. Trade libel. And final count of the amended complaint is Nemex's trade libel. Under trade libel, a corporation may recover damages for injuries suffered because of a written or oral publication of false defamatory matter which tends to be prejudicial in the conduct of a trade or business, or to deter a third person from dealing in business with him. Does that sound familiar? I don't know, Levy County. Just saying. Like, yeah. However, the plaintiff is required to demonstrate that the publication was of and concerning the plaintiff. The defamed person need not be named in the defamatory words in the communication if the communication as a whole contains sufficient facts or references from which the injured person may be the person's received the communication. Hey, Randy, I know this is definitely not going to be seen by Randy because he doesn't watch my What the Hail streams, let alone my streams that have nothing to do with him. But, like, this would be a good one for Randy to use in the federal cases, wouldn't it? Wolfson v. Kirk? The relevant inquiry is whether the average person, upon reading the statements, could reasonably have concluded that the plaintiff was implicated. Nemex is not specifically named or mentioned in the article. At best, there is a reference that Young blamed CNN for destroying his business, and that Young's business helped smuggle people out of Afghanistan. Ooh. Emphasis added in the article. On a motion to dismiss, the court is not in a position to determine if an average reading would have concluded that Nemex was not implicated in any way by the article. But even if the court accepts plaintiff's conclusory allegations as true, Nemex's claim fails. As a matter of law, there was nothing defamatory in the article that could be imputed to Nemex, and the reporting in the articles is covered by fair reporting privilege. Ay. Therefore, count 3 shall be dismissed. In addition, defendant moved for summary judgment, arguing the article was not of and concerning Nemex. Plaintiffs have not come forward with any evidence that any reader of the article believed Nemex was implicated to create an issue of fact. On that basis, judgment in favor of defendant would be appropriate as well to count 3. Hey, Taz, thank you for the $2 super chat. Missed all. I refused to watch network news. It's all one-sided. Yeah. And somebody mentioned earlier it's all owned by the same people. Florida Anti-SLAPP bars a person from filing a lawsuit against another that is without merit, and primarily because the defendant exercised the constitutional right of free speech in connection with a public issue. The statute further authorizes an expeditious review and resolution of the claims and the award prevailing party fees, costs incurred in connection with a claim that an action was filed in violation of the statutes. Florida Anti-SLAPP statute does not change the burden on a plaintiff in a defamation case, nor is it an immunity granting statute. Rather, it is a garden variety fee shifting provision which the Florida legislature enacted to accomplish a fundamental state policy deterring SLAPP suits. Bongino versus Daily Beast. Southern District of Florida 2020. There occasionally is a case that is cited where I'm like, I want to read that case. Dan Bongino versus the Daily Beast. Bring it. Stating that the statute is more than simply a garden variety fee shifting statute, citing a possible damages recoverable, along with the court amending the appellate rules to allow immediate review of non-final orders denying qualifying anti-SLAPP motions. As used in that statute, free speech in connection with public issues includes any written statement protected under applicable law and made in connection with the news report. A claim is without merit under that statute if a plaintiff fails to state a cause of action for defamation because the alleged statement is not defamatory, actual malice is not established, or the claim is barred by a privilege. Corsi versus Newsmax, there's another one. In supporting its argument that Florida's anti-SLAPP statute applies, defendant relies on the fair reporting privilege, lack of defamatory meaning, and the article not of and concerning Nemix, which have been discussed above to demonstrate that claims lack merit. In opposition, plaintiffs rely on the word choice contained in the article and the record in the CNN case to argue their claims have merit. Out of her mouth. Based on the above discussion, the court concluded that dismissal and/or summary judgment in favor of defendant was warranted because it was protected by the fair reporting privilege. The article was not defamatory either by or per se or by implication, and the article was not of and concerning Nemix. Accordingly, plaintiff's claims are without merit. Further, this lawsuit arose out of defendant's news report on the CNN case, and therefore this concerns free speech in connection with a public issue. Therefore, Florida's anti-SLAPP statute applies, and defendant, as a prevailing party, is entitled to recover its reasonable attorney's fees. This is why you don't bring a claim that you don't think you can win. And his attorneys should have probably his attorneys should have probably been smarter and been like, listen, you just won this much. This is probably going to lose because of SLAPP and the fair reporting privilege. You probably should just not do it. But yet, they opened 3 or 4 cases. Plaintiff's amended motion for leave to amend. Disposition of this motion is primarily governed by the dismissal of plaintiff's claims in this case. For this reason, plaintiff's amended motion to leave is denied. Even if the court were to examine the proffer in this case, it falls woefully short of sufficient evidence to support a claim for punitive damages. To plead a claim for punitive damages, a party must comply with Section 768.72 of Florida statutes. It provides that no claim for punitive damages shall be permitted unless there is a reasonable showing by evidence in the record or proffered by the claimant, which would provide a reasonable basis for recovery of such damages. A defendant may be held liable for punitive damages if the trier of fact finds that the defendant was personally guilty of intentional misconduct or gross negligence in accordance with that statute. Whoa. Intentional misconduct occurs when the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage. Footnote, plaintiffs did not dispute application of the anti-SLAPP statute on this basis. The article was not free speech in connection with public issues. Hence, the court determines that the article was a news report that falls within the definition as one element of anti-SLAPP claim, which is supported by applicable laws cited above. Hey, Taz, thanks for being a member for a year. Here to show Squid and her family my support. I appreciate you so much. Hey, Midas Claw. Oh. And Robert, feel better. Hope you're doing okay. And thanks for all those reels you send me. Some of them where I'm like, I don't even know if I want to open that. Gross negligence indicates conduct by the defendant was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of the person exposed to such conduct. A corporate employer, like an individual employer, may be held liable for punitive damages based on legal theories of either direct or vicarious liability. And I know they're not here anymore, but I can't. I'm having a brain fart. I know they're not here anymore, but who mentioned it earlier? Devil Fan, about why an individual does the talking or the writing and the corporation gets sued. That's why. That's not me and my opinion anymore. That's the court system. In the case of an employer or corporation, indicates that that statute indicates punitive damages may be imposed for the conduct of an employee only if the employee was guilty of an intentional misconduct or gross negligence, and the employer actively and knowingly participated in such conduct. Or B, the officers, directors, and managers of the employer knowingly condoned, ratified, or consented to such conduct. Or C, the employer engaged in conduct that constituted gross negligence. In other words, to hold a corporate employer vicariously liable for punitive damages for the acts of its employees, the plaintiff must establish 1, fault on the part of the employee that rises to the level of willful and wanton misconduct, and 2, some fault on the part of the corporate employer that rises to the level of least ordinary negligence. I know they're not here anymore, but Devil Fan, if you rewatch at the 2-hour mark, you will get your answer. The finding of a reasonable basis under the statute requires a legal determination by the trial court that requirements of that statute have been met. The standard that applies to determine whether a reasonable basis has been shown to plead a claim for punitive damages should be similar to the standard that is applied to determine whether a complaint states a cause of action. In evaluating the sufficiency of the evidence proffered in support of punitive damages claim, the evidence is viewed in the light favorable to the moving party. Ugh. Despite plaintiff's argument to the contrary, there's authority that indicates the standard for punitive damages requires the need to demonstrate actual malice, express malice, and conduct sufficiently egregious and outrageous in the context of a defamation case. All these cases holding that under Florida law, common law malice, described as ill will, hostility, or an evil intention to defame and injure, is required to plead and prove an entitlement to punitive damages. And that case holding that express malice or ill will, hostility, and intention to defame or injure, wantonness, or outrageousness of the tort were required. For actual malice, a plaintiff must establish that the disseminator of the information either knew the alleged defamatory statements were false or published them with reckless disregard despite awareness of their probable falsity. Discussing actual malice in the context of a defamation claim by a public figure, for express malice, when the motivation to harm the plaintiff is the purpose of the communication, instead of a desire to protect a proper interest, the express malice is proven. Randy, I found another case for you. I mean, I know Randy probably knows most of these cases, but like, I'm not even trying, and I'm finding cases where I'm like, this could. I mean, Taz, every state has its. I mean, take the judge in Milwaukee. Like, every state has its shit. Mostly cities, in which case, but every area has its shit. Like, but the fact that these are in Florida, these are all Florida cases, so these can apply to. Randy can use all these. This is where I'm like, Taz, easy there. Florida is nowhere like New York. New York is more like California. Oh, now New York City. Woo! In the find out portion of that fuck around and find out equation. Should be an interesting experience. In order to award punitive damages in a libel action, ill will, hostility, or an evil intention to defame and injure must be present. However, the jury can find these elements either from the evidence produced at trial or from the character of the publication itself. In the instant case, plaintiffs primarily rely on the article itself as proof of actual malice, express malice, and ill will. In essence, plaintiff's argument here is we asserted a cause of action for defamation, and therefore we are entitled to plead prove a punitive damage claim. The court is not aware of any authority, nor did plaintiffs submit such, that says someone is automatically entitled to claim punitive damages just by alleging a defamation claim. And this court is not prepared to reach this conclusion. Even if this were law, the statements contained in the article are not defamatory per se, such that malice could be presumed, and therefore plaintiffs would not pass this threshold to be entitled to claim punitive damages. Oh, I hope New York doesn't get as bad as California. I might not care quite as much if we had their weather, but no, we don't want New York to become any more like California. It's bad enough as it is. And I'm convinced it's just the cities. Because just, I don't know. If you take someone from the city and you put them in a rural area, they're going to have an issue for a while. It's going to be a culture shock. They will not get it. They will not understand it. But just maybe, if you put them in the rural area, they just might understand things from other people's perspective just a little bit better. A little bit. Ugh. Yeah, I heard about that. I was thinking about covering that because it's federal. So I like federal because I like having easy access to all the documents. It's the one thing I love about federal. I don't have any access to courtrooms, but I have access to all the documents easily. I have to pay for them, so there's that. But like, I know where to find them easily. Yeah, so much for never forgetting. Beyond the statements contained in the articles, plaintiffs refer to the amount of information about the CNN case that was available to the author. And I feel like now the judge is starting to just repeat himself. Defendant's reaction to the pre-suit notice that infers that the inference can be drawn from the words in the article itself. Watch her. As discussed above, the decisions are not defamatory, but rather protected by editorial choices. As such, plaintiffs cannot rely on the choices made by the defendant to substantiate a claim for punitive damages. Since none of the statements in the articles were defamatory, this could all have been written in like probably 5 pages. Here we go again. Color changing. You spit out that water, we got a problem. See, she holds it in her mouth. She's holding it in her mouth right now. Swallow it. Don't spit it out. Angel. Thank you. Since none of the statements in the articles are defamatory, plaintiffs not proffered evidence of actual malice, express malice. Hi, Angel. Plaintiffs have not met their threshold of burden of proffering sufficient evidence as would support punitive damage claim in this case. In addition, to hold defendant liable for the article written by Botter, plaintiffs. Ow, 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 ow. Hi, baby. It's okay. Oh, he said hi. Tat says hi. You want to say hi? Okay. Oh. We probably would have been done like 20 minutes ago if it weren't for all these interruptions. Plaintiffs are required to demonstrate that Botter was guilty of intentional misconduct or gross negligence, and defendant actively and knowingly participated in such conduct, or the officers, directors, and managers of defendant knowingly condoned, ratified, or consented to such conduct, or defendant engaged in such conduct that constituted gross negligence. Here's my question. Would an editor say this was defamatory? Would an editor be considered a director, manager, or an officer as far as this goes.
Mommy, I
I don't know. If anybody knows, let me know. Oh, yep, you can have it. Yep, you drew all over it. See? You weren't supposed to draw all over it, but you did anyway.
Mommy,
Angel, okay, come on. Oh my goodness.
ah,
Ugh.
mommy. I want
We see a lot of people from Illinois down here, and I hate it. I don't want to see any more fibs in Georgia than I did when I lived in Wisconsin. There is zero evidence proffered. Finally, plaintiffs argue that defendant's failure to retract the articles is evidence of actual malice. The one case cited by plaintiffs only suggests that failure to retract could also be considered evidence. And not that it alone is sufficient evidence. Further, plaintiff's argument flipped 770. We might have to get going because hey, can you go get your phone?
No,
Go get your pad?
no.
No. Okay. Well, you know. Angel, there's your microphone right there. There's your microphone. You see it? Here. Here, you talking to your mic. She has her microphone right here. There's yours. Well, you know, I can't stand the weather.
Mommy,
You gotta be quiet, Mom. She's literally doing this on purpose. No. 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 Oh, goodness. All right, so we're going to skip a little. Defendant's motion to... Angel, you need to be quiet, please. Defendant's motion to strike with premised on hallucinations that a... Okay, you got to get down. You're distracted. Oh, my goodness. Go get your pen. Temper tantrum in 3, 2, 1. Defendant's motion to strike was premised on hallucinations that appeared in plaintiff's original motion for leave to amend. Specifically, defendant identified 2 citations contained in the motion, one case that did not exist, and a quotation. You gotta go. You gotta go. I can't. No. You gotta stop. You gotta stop. I just don't understand. This did not exist. Upon review of the original motion, defendant's counsel indicated that it reached out to plaintiff's counsel to find a source for the authority cited. Sorry, I had to tell her to go to the other room because honestly, like, I don't mind her sitting on my lap, but when I can't talk without her talking over me. All right. Oh, we're almost done. I just don't get this. And hearing plaintiffs' counsel did not provide a valid explanation for how non-existent citations were inserted into his motion. However, counsel did assure the court measures were taken to confirm citations with legal memoranda, and in fact that counsel had hyperlinked all citations to the subsequent memoranda of Westlaw or Lexis search database. It's weird. Weird. Defendants cited several cases, mostly federal, where the court sanctioned counsel for filing briefs containing AI hallucinations or other non-existent citations. In this case, defendant asked the courts to strike the amended motion for leave to amend, require a plaintiff to obtain leave of court before filing another motion to amend, and require plaintiffs to include a certification in any other filings regarding the citations or quotations used. The court is aware of the problems that have been encountered by lawyers' use of AI to generate court documents. Oh. And plaintiff's counsel did not provide a satisfactory... Stop. Satisfactory explanation. Oh, that would piss the judge off for how non-existent citations appeared in the original motion. I mean, I don't advocate for using AI for this, but if you are going to, how about you actually fact check? Because AI is not perfect. Like, the court does not condone errant or fictitious citations. However, under the circumstances of this case, additional sanctions are not warranted. He got lucky. Another AI filing from an attorney. See, I can see using AI as like, hey, can you search Westlaw for cases involving defamation per se? And just getting a list, but then you actually have to go through and click on the cases, because I've used AI to search for, hey, can you run a PubMed search for articles on low back pain and sitting? But then you actually click on the articles and you read the articles. Or if you see a quote, like I've actually had ChatGPT give me a quote. And I'm like, that quote doesn't exist. I've read the article, that quote doesn't exist. Like, nice try. You know, when you ask it for a quick summary on something that you want to see, like, is it worth it? So I'll ask it for a quick summary of an article and I'll be like, is this worth reading? And it gives you a quote from an article. And it's like, you read the article and you're like, that quote doesn't exist in that article. So you have to, when you use AI for things, you have to fact check AI. You can't just go, AI, do this for me, and copy and paste. That's not how that fucking works. AI can be a tool to help cut down on time that is used in a search. Because now, instead of me having to sit on PubMed for hours and type in keywords and copy and click, it'll give me a list of 5 articles to look for or to look at. But it's like, I still look at the article. You don't just, I just can't see completely disregarding like actual research, Yeah, that's what I like. I always ask it to give me the links to the articles, because that way I can read the articles. It finds the articles for me. When I'm going to use 2 or 3 articles, I'll say, give me a list of 10. I'll pick 2 or 3 that I think are valid or that fit. But now I'm not having to sit for hours on PubMed like I used to. Oh God. So it's 4:20. You want down?
Yep.
Okay. I'll see you. See you. Bye. It's just weird that I don't understand how you use AI just to write something and just don't fact check. Like ChatGPT even gives you a disclaimer. AI is not always correct. Please, use your own discretion. Just fucking weird. With AI, it's hard to tell what's real. Well, I always have when I use it for things like research, I always have it provide me with links. And when it provides you with links, then it's like, you know what's real. If you just take it at face value and you don't have it provide any links, then it's like, okay, then it's a problem. Court is denying plaintiff's amended motion for leave. So the first two requests for relief are moot. Further, the court defines it unnecessary for counsel to append a separate certification for any memos or briefs. All members of the Florida Bar are governed by the rules regulating the Florida Bar. To extent the lawyer's name and bar number are affixed to the bottom of any document and filed in a court file, such signifies that the attorney has, one, read the document. To the best of the attorney's knowledge, information, and belief, there is good ground to support the document. The document is not interposed for delay, and the document contains no confidential or sensitive information or such has been properly protected. Florida rules of general practice and judicial administration. If a filing by an attorney violates the rules regulating the Florida Bar, it certainly can subject the lawyer to disciplinary action, sanctions, or other appropriate sanctions. It's AI pulls from any source, regardless of it's factual or not. That's why we should be checking the validity. Yeah, and that's why you will. I don't know what y'all do, but when I use ChatGPT, I always say, "Hey, please provide me." I actually went into ChatGPT and I said, I made one of the rules. Anytime you help me with a search, please provide links for the searches. So I always have clickable links. I don't know, but I also watched YouTube videos on how to use ChatGPT like properly. I don't know if that makes sense. Like not proper, maybe properly is not the right word, but to the best of its ability. I don't know. I'm even using it to help me like track my fasts, and it made a training journal for me for increasing my 1 rep max for my clean and jerk and my snatch. So like it, and it provided me with links on where it got the information on why it thinks that this is a good idea and which drills are a good idea. I'm like, what what do you mean? Yeah, that's the thing. I question everything though. I question everything. I was that kid that always asked why. Pretty sure I pissed my parents off. Oh, a rep counter. No, I literally have it where it's like this morning it helped me connect my, because I remembered where I put this arm, but I couldn't remember where I put the like links. So I took a picture of it and I put it in ChatGPT and I'm like, here's the end of my mic right now. Here's the end of the mic arm. What do I need to connect the two? It was very helpful. But I have I put in here like it made me a PDF of so it's like my clean and jerk technique builder target. And it said what are your it asked me like what are my biggest problems and stuff like that, and I'm like, he's like, and it goes, just to confirm, you like it formatted the same way as your the other technique, 4 weeks, 2 focus sections per week, iPad friendly with cues and checkboxes. And I'm like, sure. Like just it keeps me accountable. I find that I like it for simple things like that, and like PubMed searches where it provides me with links and I don't have to just sit and search. Because on PubMed, like you get 80 pages of results and you're sitting there clicking and clicking and clicking. It's like, just give me 15, 20 articles that have these keywords in them. And, then it narrows it down from like 100 results to like 20. And it's so much easier. It makes it so much quicker. I have it running daily searches on certain things for me based on what I'm doing that particular week. It's great, but it's also, you take it with a grain of salt. Even when I run legal documents through it and I'm like, analyze this for if AI wrote it. whenever I present it to you on a live stream, I'm always like, I ran this through ChatGPT, so take it with a grain of salt. However, I compared a document that was signed by a person to this document that was not signed by this person. And ChatGPT thinks the same person wrote it. But you take it with a grain of salt. It's like a lie detector test. It might be accurate, but it can't be used in a court of law. In this case, plaintiff's claims are being dismissed with prejudice, and defendant is being awarded fees and costs under the Florida Anti-SLAPP statute. There would be no need for the relief defendant sought in its motion. For these reasons, motion to strike is due to be denied. Conclusion. Thank God. This brings us back to the beginning. This case was a second sequel that should not have been made. Unlike the CNN case, this is a forced plot without any character development. Under applicable law, there is no villain. Rather, this is an attempt to repackage the CNN storyline again against a different opponent. After screening, this is a production. The court determines that the sequel should not be released because under the facts, this third installment does not work. The judge is a movie buff. Footnote, the court was directed to Florida Bar Ethics Opinion 24-1, which addressed the use of artificial intelligence in the practice of law and referenced several bar rules that could be implicated. Due to the importance of this issue in maintaining legal ethics, it's appropriate to quote several paragraphs from Opinion 24.1 here as applicable to the issues. Second, a lawyer must review the work product of a generative AI in situations similar to those requiring review of a work of non-lawyer assistants, such as paralegals. Lawyers are ultimately responsible for the work product they create, regardless of whether that work product was originally drafted or researched by a non-lawyer or generative AI. Like, I think it's totally appropriate to use AI for search purposes because sometimes the searching for shit is what takes forever. And if I was able to find certain documents in certain cases with the help of AI doing a search for the case number, and it was like I was able to find documents that I didn't have to pay for. And it was so helpful. But it's at the same time, it's like it's a search assistant. It's not someone to do your work for you. Yeah. I sent you a DM. I saw that you sent a DM. I hadn't oh, funny story. Oh my goodness. That should be an interesting time. As an attorney, we know just lost an appeal on sanctions for that exact thing. It's like it's just it's an assistant. It's not someone to do your job for you. Functionally, this means a lawyer must verify the accuracy and sufficiency of all research performed by generative AI. I'm working on writing a script for that score video. I'm trying to make it longer, because when I know I'm going to like cut stuff out of it when I edit it. So I'm having AI search for things, doing searches for different schools and different things. Well, it told me what the SCORE Act stood for, and I'm like, that's not what's in the damn bill. Like, you gave me the link for the damn bill, and you didn't even tell me the right name for the bill. So it's like AI, for as good as it is, it's not good at the same time. So it's like you always fact check. Like, yeah. The failure to do so can lead to violations of the lawyer's duties of competence, avoidance of frivolous claims and contentions, and candor to the tribunal. In sum, a lawyer may ethically utilize generative AI technologies, but only to the extent that the lawyer can reasonably guarantee compliance with the lawyer's ethical obligations to these obligations, including duties of confidentiality. Okay, go on. Down. Go try. Try. Girl, you're gonna hit your head. You ever notice like little kids when they like swing and it's like they spend so much time trying to fight something that they end up like hitting their head on something? She's gonna do the corner here. We need to get some stuff for the corner. Stop. Okay. You got all right. So it is ordered the Associated Press motion to dismiss, or in the alternative, motion for summary judgment is hereby granted. Plaintiffs' claims are dismissed with prejudice, and summary judgment is granted in favor of defendant. Plaintiff's amended motion is denied. Associated Press motion to strike is denied. Under Florida's anti-SLAPP statute, defendant as prevailing party is entitled to recover from plaintiffs reasonable attorney's fees and costs, including incurred in defending these claims. Any and all other relief requested is denied. The court reserves jurisdiction to determine the amount of defendant's taxable fees and costs. And that's the same William S. Henry, judge. And then all the lawyers are on the last page. So we are finally done with that document. We are finally done with that document. Whoa. Angel, stop, please. There we go. So we are going to get going. The little needs mama attention now. Yes, Jeffrey, she is saying I shall be heard. I have no problem with her being up here. It's when she screams and she's whenever I try to talk, she yells over me. It's like I can't imagine wearing headphones, what that must sound like for y'all. So we are going to get going. We'll be back tomorrow with any updates in the crazy Florida drama. There are some documents in this case that have been filed up until yesterday. Wait, 10/31. There was a receipt for $360.50. There's also some other documents, exhibits that I don't have permission to access. So I requested access to some, and if anything is granted, we will be reading it. But there is a whole bunch of stuff. But the case is closed, and all the cases are closed. So y'all have a great night. I am going to figure out what to do for dinner, because we need to eat something besides Nutella and toast. Yeah, because all we've wanted to eat the last 3 days is Nutella toast, and we can't live off Nutella toast. So we're gonna go see what we could make for dinner. All right, y'all have a great night, and I will see you guys on. Oh, Devil fan, the 2-hour mark. You get your question answered about why a company can get sued and not just the person. The judge literally put it in the document. It's at the exactly 2-hour mark. So I mentioned you because I was like, I knew you were asking that question. So, but I will see. Ow. I swear this girl's trying to kill me. Quick comment to count my view. And I appreciate the engagement. Girl, you gotta stop screaming. Bye bye. You're gonna yeet us out of here. 1, 2, 3.